Hey, what's going on, everybody? This is New York Times versus the United States. All right. So let's make this bad boy happen. All right. So this case is extremely important, because it has everything to do with privacy, um, as well as how far the extent of power does the executive branch actually have versus the right for the people to know what's going on a domestic scale regarding people's lives, regarding war, regarding the information that newspapers believe the people should know. All right. So let's get into the New York Times versus the United States. All right, a little bit of background. The New York Times and the Washington Post wanted to publish the classified quote unquote Pentagon Papers. Now, if you ever have the opportunity to go and watch the movie called The Post is actually should be on Hulu. The Post is an interesting movie. The Post specifically talks about what happened to the Pentagon Papers in regards of the Vietnam War. In other words, what are all the transactions and the information which was set back and forth from different government officials as to why we got into the Vietnam War, but not just got into the Vietnam War, continued with the Vietnam War over for a number of years, right? And the Pentagon Papers classified Defense Department study regarding the history of U.S. activities in Vietnam. One, how we interacted with the government, how we interacted with the people, and vice versa. The purpose in which we went into war, um, and the hidden agenda, therefore, within both Democratic and more importantly the Republican Party at the time for Vietnam War. Now, this situation was actually rushed to courts, to the local courts. And the reason why it was rushed through local courts is because the New York Times and the Washington Post basically published the papers simultaneously. And it went throughout the United States and was a bombshell as to exactly what happened within the United States and how, in like for a better term, corrupt some politicians can be to get their agenda out behind the backs of the American people, knowing they had the trust of the American people. So much attention and importance was laid across the line here. It was specifically argued on June 26, 1971, and decided on June 30th, 1971. And then when I mean rushed through the courts, it was literally rushed quickly through the courts. And this rushed through much faster, obviously, than any other case that we went through, right? We talked about Brown versus Board of Education. We talked about Marbury versus Madison. We talked about McCullough versus Maryland, and how the process that went through took a number of months, if not years, for it to go through. This case, it took a matter of 3.5 days. And the purpose of it was that both newspapers needed and wanted to publish this information to the people because they felt it was necessary that the people understood what was going on within the executive branch and how it has affected the outlook of America at that time. So the circumstances of the case itself. One, the Pentagon Papers, officially known as the history of U.S. decision-making process on Vietnam policy. In other words, it specifically talk about how we in the United States dealt with Vietnam, as I stated to you before, but not just dealt with Vietnam on an economic basis, but on a political basis, on a strategic basis, on a military basis, on all fronts of foreign policy, it dealt with Vietnam. And the fact that they were illegally copied and then leaked to the press. In other words, these numerous hundreds, practically thousands, right, of pages was illegally copied from what we now consider in America, what we now call individuals in America, what you would call like snitches, right? Or whistleblowers for a much better term, right? And this was sent to these two newspapers because this particular whistleblower was concerned as to what's happening in America currently. So the New York Times and Washington Post had obtained these documents and acting at the government's request because they contacted the government about this. The United States District Court in New York issued a temporary injunction. In other words, it's a court order that directed the New York Times not to publish these documents. In other words, the U.S. District Court, the government attorney general, rushed through the court system to stop the publishing of these papers in the newspaper on a day by day basis, right? So they quickly went to the courthouse to get an injunction and to stop the presses. The Pentagon Papers surfaced at the time when American people were deeply divided on the question of the United States' involvement in the war. Excuse me. This is important because we talked about this before in class, right? The fact that we had so many people, literally and figuratively, like fighting in the streets, protesting the concept of the Vietnam War, and was highly upset that we were going to war over this issue, that something needed to be done immediately because too many people's lives were at risk. They went through a messy draft that put people's lives in danger over a long and elongated, period of time. It was just a very bad time overall, which people were going through. So the issues, right? Let's go over the issues. Certain questions need to be answered, right? One, are the papers, the Pentagon papers that are, allowed to publish the Pentagon papers, or the newspapers are allowed to publish the Pentagon papers with risk of government censorship? In other words, does the newspapers, or any newspaper that is, even if it's large newspapers like the New York Times or the Washington Post, or smaller newspapers like the Times Picayune or the Houston Chronicle, right? Doesn't matter. Should these newspapers be allowed to publish classified information which was sent by a whistleblower to put a spotlight on corruption within government? The second question happens to be, are the freedoms provided by the First Amendment absolute? In other words, are there any way to curtail or to curve or to limit First Amendment, in particular, freedom of the press or freedom of speech? The third question is, did the threat of national security outweigh the freedom of press guaranteed by the First Amendment? This is a better way to phrase the second question. In other words, what it's saying is this. It's specifically asking you overall, the freedoms that the threat to national security, if any information that has been leaked or a whistleblower has sent out to national, international, or even local newspapers, if that information in the government field is a threat to national security, that may be a threat to our safety as a nation, should these newspapers be able to publish the information in lieu of this national security issue? Do the people have a right to know what the government is doing on a consistent, regular basis? And the final question is, did the publication of Pentagon Papers, in fact, pose a threat to national security? It's another way to rephrase question number 3. If newspapers publicate any sort of government issued documentation that can possibly be a threat to our security, should these newspapers be able to do so? Should it be legal? Is it justifiable? So one of the concepts we have to understand is the First Amendment, right? We talked about the First Amendment, the freedom of speech and the freedom of the press, right? These are supposedly absolute amendments, but we well know that freedom of speech can only go so far, and the freedom of press can only go so far. In particular, to the case in regards to like school newspapers, like Tinker versus Des Moines, like other news. I'm sorry, not Tinker versus Des Moines, but other cases that deals with newspapers in schools or anywhere else, right? B, the rights of newspapers, First Amendments versus the executive branch responsibility to protect the nation. In other words, what do you value more? The absolute right of free speech in the press, or the right and responsibility of the president and his cabinet to keep us safe? Next, let's go over these arguments, right? So, it's important that now that we have a firm background, right, we have an understanding of what's happening in regards of this. It is also important to understand what were the arguments that are made by not only the New York Times, but also the government themselves, right? One of the very first arguments that's made by the New York Times is that the First Amendment guarantee of freedom of the press protects the newspaper in the publication of these documents. In other words, what the New York Times is saying, with conjunction with the Washington Post, they are specifically stating to you overall the First Amendment right that is granted to the newspapers for freedom of the press protects newspapers in any such publications overall, as long as it is informing the public about what is going on in society, because it is the right of the people to know what is going on in society. On top of that, the New York Times also talks about one of the few restraints on executive power in matters of national defense is a knowledgeable population. This specifically saying the way that we as individuals evolve and understand about our government and ourselves is to be informed about matters that are important and sometimes matters that may not seem as important as others. To restrict the right to know, you are fundamentally restricting the right that we have within our First Amendment rights, which is the freedom of the press, the freedom of speech, the freedom of religion, the freedom of assembly. We're losing those freedoms if the government is allowed to keep relevant information away from people who need it to make informed decisions about their lives overall. The New York Times lawyers also state that the press must be free to inform the American people. Look, the New York Times is saying the people have a right to know what's going on. The people also have a right to ignore what's going on. But first and foremost, the newspapers have a responsibility, a fundamental responsibility to grasp what's going on in the government. By the way, not just the government, right? But also what happens in the Supreme Court and what happens in the court system. The people also have a right to know what's going on in Congress, whether it's good, bad, or indifferent. The people have a right to these concepts. And the last argument the New York Times make is that the government has failed to show that publication of the Pentagon Papers would endanger national security. In other words, what the New York Times is saying is that in the briefs, we talked about briefs before, right? Summations or evidence or information that's given to the judges in regards of why said case should go one way versus the other. All right. So the New York Times lawyers are saying, look, the information in which what the lawyers for the government is saying right now seems fundamentally interesting, right? It's a not bad of an argument, but overall, that argument pales in comparison to the arguments in which we're making, right? The government did not show enough within their case to explain to people or explain to the judges as to why the Pentagon Papers needs not be published. All right. So it's important to understand that. Now, these are the arguments set forth by the New York Times. All right. Now let's go over the arguments in which the United States is making in regard to the Pentagon Papers. Now, the United States arguments are very clear, straightforward, and effervescent. In other words, one argument they're making is that the First Amendment does not guarantee an absolute freedom of the press, especially when the nation's security is involved. In other words, if the papers that has been leaked by this whistleblower can fundamentally harm the long-term viability and the long-term health of the United States, therefore, the right to publish by the press should not occur. The fundamental issue here is the fact that the United States have an obligation to protect its citizens above all costs, even if the freedoms of certain people and even the freedom of the press is harmed overall. All right. Now, the next argument they make is that the courts must strike a balance between the fundamentally important right to a free press and the equally important duty of the government to protect the nation. All right. Now, this is fun. This is important to grasp, right? This is their most important argument overall. The United States Attorney General is making an argument here by saying you, the Supreme Court, must be willing to strike a balance between the right that the newspapers have overall, at the same time, what will best benefit the nation overall. That is a fundamentally important concept. And the reason why I'm saying this is fundamentally important is because that they're putting the onus, they're putting the power upon the plate of the Supreme Court with the hopes they understand that the balance of the right to know versus the balance of security must be very distinct, right? Now, the third argument is allowing the publication of these documents would establish a dangerous precedent for future cases involving national security. The last argument they're making here is this. Look, they're telling the judges, if you allow the Washington Post and the New York Times to publish this information, you are going to fundamentally and irreparably harm the image, the power that the United States government has and the military has overall. In other words, the United States will not be trusted on a global scale for a very long time, if at all, ever again. And they're putting this pressure upon the court system, hoping and wishing upon a prayer, right? That the government, that not government, excuse me, the Supreme Court would buy into the argument and would vote for them as opposed to the New York Times. The decision was a 6-3 for the New York Times. And simply put, the national security was too broad of an issue to legitimize prior restraint. In other words, the 6 judges that specifically voted for the New York Times said quite simply this: look, the concept of national security, the definition of the perspective of national security is too broad. It's too broad to restrain the people's right to know. Right? So they're saying, look, if you verbalized to us the fundamental issue and definition of national security, you may have won this case. In other words, you may have gotten 2, 3, or more to vote against you, against the New York Times. But because you define national security so broad, it's almost unimaginable to think of, as well as to strip away essentially the right of the press. It's too harmful long term. Plus, the publication doesn't cause inevitable, direct, or imminent event imperiling safety of the forces. In other words, they're saying just because the New York Times and the Washington Post may post what your administration did and what your administration actually escalated, that doesn't mean that's going to put our lives in risk and going to risk the national security of America. It may risk the election process for your political party, right? It may risk the concept of your future in regards of politics, in regards of military, in regards of Congress, in regards of any of these concepts. But it doesn't harm the American people based upon what your clients, right? The people who are in Congress and in the executive branch discussed overall. That won't put, all these young people in harm's way, like people will come to the United States and bomb them. That's not going to happen because you lied to the American people. The American people will have to determine this concept later on. And by determining this concept later on, determine what they're going to do about the lies that was given by that administration. So the dissenting opinion, the judges that voted for the government was Justice Warren Burger, Justice John Harlan, and Justice Harry Blackmun. And Burger dissented and argued that the imperative of a free and unfettered press comes into collision with another imperative, the effective function of a complete modern government. In other words, Justice Burger is telling you that, look, there is a clash between having power within the press to post what they feel the public needs to know. That's unfettered power. In other words, it's not fully, it's challenged, but it's not functionally challenged, right? And the fact that it comes in collision with a complete modern government. In other words, it will clash with how government is currently being worked and decided on, as opposed to the previous generation before, where it becomes much more in-depth, much more research-based, and so on and so forth. He then later argued, along with Justice Harlan and Blackmun, that in the haste of the proceedings, the quickness of the proceedings, the 4 days, and given the size of the documents, the thousands and thousands of pages in which these Pentagon papers happen to be. The court was unable to gather enough information to make a decision that is relative. And so they voted in favor of the government with the hopes that they're able to open up and be able to even have a better discourse. They voted against the New York Times because of the time frame as well. All right. The time frame was about 3.5, 4 days, not enough time to go through all the documents. And therefore, they wanted more time. And unfortunately, that more time, if it was allowed, they would have never published it in the first place. And it's going to be incredibly difficult for them to have a rehearing of the trial in Supreme Court. It's not like it's unheard of, but it's going to be very difficult at the same time. Now, the majority opinion here, the 6 justices by Justice Hugo Black, Justice William Douglas, Justice William Brennan, Justice Potter Stewart, Justice Byron White, and of course, Justice Thurgood Marshall. They're all in conjointment together, and Justice White and Justice Potter specifically stated they believed that while there are situations in which the First Amendment may be abridged, in other words, they agree that the First Amendment right, no matter what, press, assembly, speech, religion, so on and so forth, can be abridged, can be altered, can be adjusted, can be modified. They had to concur in today's judgment, but only because of the concededly extraordinary protection against prior restraints enjoyed by the press under our constitutional system. In other words, they had to vote in favor, at least these 2 justices, voted in favor of the New York Times because of what the First Amendment allots the newspapers. This unfettered power that the press actually has. Although the justices thought that the New York Times had probably gone too far in publishing the Pentagon Papers. Now, I want to be clear about this. The 6 justices that even voted for New York Times all had an inkling that publishing these papers may have went a bit too far. They found nothing in the law to prevent the newspapers from actually publishing this information in the first place. In other words, the people of the New York Times and the Washington Post had every right within the First Amendment to publish the information to the American people. No matter what the volume of papers were, they still had the power to do so. And it didn't go against the First Amendment rights or go against individual and personal rights. It went for the First Amendment because they felt it was important for the American people to understand and to know what's going on within their government. All right? With that in mind, that's it. So we spoke about the concept of about what power the First Amendment actually has as it relates to the publication of documents by the government. More importantly, how far and how much more powerful that individuals within the press has to document information in regards of either classified or declassified information. We also talked about what the decisions were by both sides, for and against, the majority as well as the dissenting opinions by the 9 Supreme Court justices themselves. We talked about the arguments each side made. The United States arguments was a three-prong approach, while the New York Times provided 4 basic, fundamental, yet in-depth analysis as to why they believed what they believed in. With that in mind, this ends the New York Times versus United States of 1971. I will be posting this. I will have manipulatives and summaries and information to be attached to this. Please, any questions, comments, concerns, please give me an email. Please email me. I'll be more than happy to answer your emails, everybody. Again, as I've always said in my other lessons, be safe, be healthy, be well. We're living in some extraordinary times right now. It is super important under the COVID-19 pandemic to do just that. All right. I'll be available to you via email. Hope everyone again stays well, and I will post more Supreme Court cases and documents later on. Be safe. Take care, everybody.